Oh, hi there. Good afternoon. Good morning if you are joining us from Alberta or BC. I am Sephton Leibbrandt. I'm an associate at Samfiru Tumarkin, and this is our live Q&A for the next 30 minutes where we will be answering your employment questions, everything ranging from terminations of employment, severance packages, layoffs, potentially human rights concerns, any employee rights concerns that you may have. Now is the time to get your questions answered here today on our regular installment of this live stream. So thank you everybody for joining us. Again, I am Sephton Leibbrandt and I'm an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. So thank you everybody for joining us this afternoon. Just to kind of get the ball rolling here while we wait for some questions to roll in. Looking at kind of the news of late, things that are important and happening that kind of pertain to employment law. What I've seen is that apparently the Mullen Group, which is a large freight conglomerate, is looking to acquire the Cole Group, which again, another large freight and brokerage company that does a lot of transporter shipping and things like that, and freight shipping throughout Canada and into the United States, is looking to acquire that other company. So Mullen is looking to acquire Cole, two very, very large companies that are coming together to make one larger company. So what does that mean for people generally who are maybe in a similar circumstance where one employer is acquiring another employer, and what happens to your service with the former employer, what happens to your rights and things like that, your severance package entitlements potentially, what goes on in that circumstance. So basically there's kind of two things that can potentially occur. For instance, in the Mullen and Cole situation, what's happening there, and the company is very clear about it, is it's what's called a share acquisition. So basically, in a share acquisition, one company just assumes the other outright and takes it on as a going concern. What this all means for you, in effect, is that if you were an employee of company A there that was acquired by company B, then basically you're in service with company A is simply inherited to the new company. You don't need to sign any kind of new contract of employment or anything like that. You basically continue working without any, typically any interruption whatsoever from one day to the next. And everything that you had with the prior company is simply inherited by the new company. So company B inherits everything that you had with company A, and you continue on from that point in time. So that's the most simple and straightforward of acquisitions. The other kind of more, less common and more complicated acquisition is basically what's called an asset acquisition. That one, you kind of know that it's occurring because usually that means that company A, so your current employer, is probably having a rough time of it financially speaking, and as a result of that, they may potentially be on the verge of bankruptcy or something along those lines, or simply in a very serious economic circumstance where another employer is going to take over, another company rather is going to take over them, but it's not going to acquire the company as a going concern. Instead, it's going to acquire things like the assets of the company, so the office chairs and the desks and the computers and things like that. And as part of that, it may then offer you, the employee, a new offer of employment with the new company. And again, this doesn't happen too often, but it is something that is a little bit different than just one employer was your employer was one thing one day, company A one day, and the next day it was company B. Instead, a little bit more complex. Basically, what happens in an asset acquisition is that your employment with the prior company is terminated, and then potentially through some agreement with the new company that's taking over, they may offer you, a new job with that company, and then there may be potentially, provisions made in your new contract there to recognize prior service or not. But that's a little bit of a different situation. So if you're in that situation, an asset acquisition where you're basically whatever the company tells you, your employment is terminated. Once that new company has acquired the assets there, and then you have the option of either going and finding another job, or potentially if the new employer comes to you and offers you a position, taking that job instead and signing typically a new contract of employment to do so. In that particular situation, definitely something you want to reach out to an employment lawyer like myself about, or to the firm generally, because in those situations, you're going to want to have the contract looked at and reviewed to make sure, number one, first of all, does the previous company still owe you a severance package? And what is that? And the new offer of employment that potentially the company that's come along has given you, is that actually a comparable job, or is it not? Is it something else? And if it's not a comparable job, then definitely something you want to try to get a severance package potentially for, out of the previous company, if it's not the case that you're basically continuing from one to the next. So that kind of kicks us off there. I'm seeing a bunch of questions rolling in now, which is fantastic. So let's jump right into those without further ado. So looks like Glad to See from YouTube has asked, is an employer allowed to require a 6-month probation period? Is there a limit to how long this can be? So that's a great question, Glad. Basically, whatever the contract says about it is, the probationary period, the employer, could potentially require, quote unquote, a probationary period for however long effectively they want. Generally, probationary periods are, between 3 months and 6 months at the highest possible extent. But ultimately, whatever the contract says is effectively irrelevant. If the contract says, for instance, 6 months probation, that doesn't mean that they can terminate you within 6 months and pay you nothing. Presuming that you are a provincially regulated employee, so you're not, in interprovincial trucking or federal, banking, mining, other, airports, for instance, other kind of, federal jurisdiction companies. If you're just a provincially regulated employee, which the vast majority of people are, then ultimately the probationary period under the ESA, where the company has to potentially provide you with at least your ESA minimums, is the maximum of 3 months, and that's it. And once you achieve the 3 months, then after that point in time, they need to provide you with at least the minimum requirements as provided by the Employment Standards Act of Ontario, presuming that you're in Ontario, of course. It's relatively the same thing for BC and Alberta as well. But so that hopefully that answers your question there. They can put effectively any number in the contract for what the probationary period is, but it doesn't change what your actual legal entitlements are. Under the legislation, for instance, or even potentially to a severance package. Basically, once you go along there and they terminate your employment, let's say within the 6 months probationary period they list in their contract, or even if it's a longer probationary period, let's say it was a year for some reason, that wouldn't affect your legal entitlements under the ESA, the Employment Standards Act, and then potentially you also be entitled to greater severance package at common law, depending on what your contract says, if there is a contract, and things like that. So hopefully that answers your question there, Glad. Again, the contract, what it says about probationary periods is not really relevant. The primary thing is that under the Employment Standards Act, you basically can't be terminated without notice once you get to that 3-month service mark. After that, you're owed at least the minimum amount of notice under the ESA, and potentially more at common law. And even it may be the case that within 3 months, you may be entitled to a severance package at common law anyway. It kind of varies there. Long story short of it, the contract really isn't the most relevant thing in what it says, and not usually the most relevant thing. The best thing that you can do in the circumstances is that if there's an issue, if you're terminated at any point, reach out to us. You can find our information on employmentlawyer.ca, and just reach out to one of us here at the firm, and we can have a look at the circumstances and see, potentially, are you entitled to a severance package? Depending on the circumstances, they're looking at your contract and so on and so forth. Because that would really answer the question once and for all. But yeah, the contract itself and what it says is, in those circumstances, usually not the most relevant. But thank you for that question. A very useful question for everybody who may be attending today. So once again, I'm Sephton Leibbrandt. I'm an associate at Samfiru Tumarkin LLP. And this is our 30-minute live Q&A. So moving right along here, looks like another question from YouTube. Looks like 4D has asked, if, for example, you're required to be a member of a professional association in order to work as an engineer or geologist in a certain province, can a professional association ban you from working? An interesting question. Potentially, yes, they could. It would have to be depending on things, probably some kind of misconduct of some nature that's you've regulatory, some kind of regulatory investigation where the association has investigated the circumstances, and they've said that you're not licensed or something like that to work as an engineer or geologist or whatever the particular profession is. For instance, lawyers, of course, one could potentially, if they engage in very, very serious misconduct, could be disbarred and things like that. So, I mean, the short answer of it is, yes. If you lack the licensing requirements of your particular professional association, then it's possible that you could effectively, be banned from working. And the long and the short of it. But otherwise than that, I mean, those situations usually don't come up very often. Usually it's very, very rare, and only in the circumstance, again, of having gone through some kind of regulatory proceeding with that particular association, and the association determining effectively that you cannot be licensed any longer, and you can appeal from that suspension or revocation of your license. Very, bit of an atypical situation. But I mean, short and long of it is, yes, it could happen, but probably quite unlikely for most people for the most part. So hopefully that answers your question, 4D. We're moving right along now. It looks like Carlos from Facebook has asked, can you request to be rehired by the new company and get severance from seller company? Okay, so I think we're jumping back to the acquisition discussion we had at the beginning of the segment here. So can you request to be rehired by the new company? I mean, yes, of course you can ask that. I mean, usually the company will probably the ones who will come to you and offer you employment. Of course, you can reach out yourself. And can you get severance? So you can't receive both effectively because typically your severance package, the purpose of it is simply to tie you over from one job to another comparable job. So if it is the case that you got another job immediately from the new company, then for the most part, you potentially may not have much legal entitlement from the previous company. The only rare circumstance would be if you're a very long-term employee with the original company, and your entitlements for instance, under the either the Employment Standards Act of Ontario or potentially the Canada Labor Code as well, were very significant because your minimum entitlements under the legislation, it doesn't matter whether you have another job or not. Those are guaranteed amounts of money. So only in that particular circumstance could you receive your minimum entitlements from the former company, presumably they actually still have assets that they can liquidate or liquid money to provide. In that circumstance, you could potentially receive both a new job, from the new employer, and your minimum statutory entitlements from the previous employer as well. It doesn't happen, very often, usually because your greatest possible legal entitlement, generally for most people, is your common law severance package, basically meaning how much notice are you entitled to find another comparable job based on your years of service, your age, and your position, and some other factors that the courts look at to determine how many months of severance, how many months of pay should you receive from another, from your former employer, so that you have some time to look for another job at a new employer. And of course, in the case where you found out you got a job offer right away from another employer, those entitlements may potentially be zero if the new job is exactly the same rate of pay as the old job. Again, save and except for your minimum statutory entitlements, provincially or federally. And again, that would really depend on, you have to be quite a long service employee to really get those entitlements up to a significant number where, missing out on that would be, a significant loss. So hopefully that answers your question, Carlos, in the circumstances. Not something that usually happens too often, but it's certainly a possibility to receive both a severance package from the previous employer and get a new job from another employer. Again, it would be the severance package you're receiving from the former employer would likely just be your ESA minimum entitlements, which would be based on how long you worked for that employer and the size of that employer in terms of its payroll and things like that. So hopefully that answered your question, but thank you for that. A very interesting question and a useful one, no doubt about it. Before we jump to the next one, I'm just going to have a quick drink of water here, but looks like we have a bunch of other questions coming in, which is fantastic. So we'll get to those just in a second. Okie doke. All right. So looks like Yazir from YouTube has asked, can an employee bring a termination without cause and wrongful dismissal claim during the probation period, and how much severance is owed if terminated without cause during the probation period? Okay, very interesting question, Yazir. Thank you for that. So the termination without cause and wrongful dismissal, so those are the same things, just so you understand. Everything is a wrongful dismissal. Whenever the employer dismisses an employee without, what a court would deem as adequate notice at common law in their circumstances, then it's a wrongful dismissal. So they're all the same thing, just so you understand from that perspective. But to get to the heart of your question, it's entirely possible that you may be owed nothing whatsoever under the legislation because you were terminated within 3 months, for instance, of starting the job, but you don't have an enforceable contract that limits you to only the ESA minimums. And so in that circumstance, you actually would still be entitled potentially to, a severance package. A lot of it would depend on, the nature of the profession that you're in, how many jobs are generally available in that profession. Of course, your age would be very, very important. If you're on, in your late 50s or 60s, for instance, that would certainly weigh very heavily in your favor. But generally, if you were terminated only within the probationary period, so you've been there for 3 months or less, probably at maximum you're looking at about 2 to 3 months of notice. And again, the circumstances would have to be quite favorable to you in that that situation. Definitely, it would be a situation where this is not a job like, for instance, maybe truck driving, where there's tons of jobs out there and you can get another job the next day. Similar, with construction as well, where there's lots of jobs generally for those kinds of folks. It would have to be kind of another profession where, again, it would probably take you at least a few months, reasonably speaking, to find another job. But yeah, no, you're correct that you can absolutely obtain a severance package at common law, potentially, like I said, for around 2 or 3 months, potentially. If the factors are right, if you have the right factors, your age is sufficient, your position and package, rate of compensation are sufficient, and things like that. Then certainly you could potentially obtain that from an employer, even if you are terminated during the ESA probationary period there of 3 months. Again, provided that you don't have a contract that effectively limits you to only the ESA minimums. And that's why you definitely want to reach out to, an employment lawyer like myself or to the firm generally to get that looked at and to get that assessed and determine, are you actually entitled to a severance package at common law in those particular circumstances. So again, you can reach out to the little link there below, employmentlawyer.ca, to find out more about that and get in contact with one of us to have a look at your circumstances. So thank you again for that question, Yazir. A very great question. Very useful one for people generally speaking, because a lot of people don't understand that even if they may not be entitled to a severance package or what minimum entitlements under the legislation. So in case if you're in Ontario, for instance, the Employment Standards Act of Ontario, you may still be entitled potentially to a severance package at common law. They're two different things, and so one doesn't necessarily mean you won't be without the other. But definitely in those circumstances where you're terminated 3 months or less, absolutely you got to reach out to a lawyer to have us look at that for you and see, is this a circumstance where you are entitled to a severance package of common law there, and how much potentially could that be? So thank you for that. Moving along here, looks like 4D from YouTube has asked again, can a professional association hold a disciplinary hearing without inviting you to defend yourself? Not any professional association that I'm aware of. You would almost always have to be present in some capacity, unless for whatever reason you were notified and you just refused to show up. But it would be very, very rare in the circumstances, I would think. Could they do so if you're not there? Potentially. But almost never, and probably presumably you would have showed up to that hearing to speak to your case and speak to your position. So I mean, the long and the short of it is, potentially could they do so? Sure, if you've been notified with sufficient notice and you didn't show up, and there was very serious circumstances, they could hold a hearing and determine on the evidence before them, the status of your license and things like that. But it would be very rare, definitely. And for the most part, again, you would always have the opportunity to say your piece, to give your evidence, to give your position before any kind of regulatory body would make a determination on its own. Again, a very unusual circumstance that would be anything otherwise than that. So hopefully that answers that question for you. If you have another one, you can of course feel free to ask it. Jumping on to the next one here, another one from YouTube. Looks like Terrible T, great name, has asked, if you work on an annual contract and have done so for many years, can an employer just make a number of changes to the contract when it suits them? So, number one, Terrible T, if you've been working on a contract that's allegedly on an annual basis for many years, you're probably actually not a fixed term contract employee in the circumstances. More likely than not, you are what's called an indefinite term employee in the company, either out of ignorance or on purpose, has mischaracterized you as a fixed term employee. So there could be kind of two circumstances. One, you're terminated at the very end of that last contract, in which case you're looking to have your full tenure with the company considered in determining your severance package. So let's say you've been there on 10 consecutive annual contracts with no break in between, and you just continue to work, then you're effectively a 10-year employee at common law, and you'd be looking for a severance package on the basis of 10 years of service. If there are breaks in the service and things like that, then it might be a little bit more tricky depending on what the reason for the breaks is. But no, I mean, clearly it sounds like potentially you're an indefinite term employee, number one. Of course, you can of course also try to treat the contract, if it's terminated, as a fixed term contract if it provides for more notice to you, because if somebody's employed on a fixed term contract, they're entitled, if they're terminated without any enforceable provisions, to the balance of that contract at law. So let's say you're only a month or two into the contract, well then potentially you may be entitled to 10 months of notice on that basis, because that's the balance of the contract that you agreed to there. So a lot of it would depend on where exactly the time period you're terminated at, where you are at in the contract itself. But typically when I see these things, more often than not, it's much more favorable to you to argue that you are an indefinite term employee and entitled to a severance package on that basis. So, like I said, if it's 10 consecutive contracts back to back, then you're looking at arguing for 10 years of service at common law and a severance package on that basis. But to jump to your question of can they just make a number of changes to the contract when it suits them, absolutely not. Again, I mean, for all intents and purposes, you're a indefinite term employee with a certain working relationship with the company. Those working relationship may be defined in the contract itself, and maybe clear language about how that all works in the contract, or it could just be a course of action that's determined what the terms and conditions of your employment are in the circumstances. So the long and the short of it is, it would really depend on the changes that they're making. If they're changes like affecting your rate of pay, for instance, where they're significantly reducing your rate of pay, that would likely be a constructive termination. If it's other things like hours of work, duties, even potentially the change of the location of the workplace itself, depending again how significant and serious those changes are, those would potentially again lead to a constructive termination of your employment, and you'd be owed a severance package on that basis, again presuming that there's no enforceable termination provisions that restrict you to the ESA minimums and only the ESA minimums. So that's the Employment Standards Act of Ontario, for instance, if you are in Ontario, or potentially other legislation if you're in another province or federally. So that hopefully answers your question there. Again, long and the short of it is, no, you can't make changes to a contract. That would be a breach of contract. But again, the changes need to be serious, significant changes to fundamental, critical terms of your employment. It can't just be like tiny things like they're changing this policy or that policy. That really has no significant or material effect on you from an employment standpoint. That wouldn't be sufficient. And the court's going to look for serious, significant changes to your terms and conditions of employment in order to determine that there's been a constructive termination and you're owed a severance package, on that basis. So hopefully that answers your question and helps you out in that respect. I appreciate the question. Thank you for that. Moving right along here. A bunch of other questions have come in. We have a few minutes left here. So it looks like Andy from YouTube has asked, is there a legal term that describes a severance agreement that specifically has a clawback clause if the former employee finds a new job, i.e. other than a standard duty to mitigate clause? So is there a legal term? Not particularly, no. What you're kind of referring to, Andy, is probably it would be a salary continuance package that has a clawback of some nature. So clawback's a little bit of a misleading term in itself, because it's not really that you're getting clawed back any money. Generally what happens is that you find another job during the salary continuance period you agreed upon, whatever it is, 10 months, 12 months, whatever. And then you notify the employer once you obtain another job, and then they pay you 50% of the balance, typically, of what is owed on the notice period. So if you agree to 16 months as a salary continuance package, you find a job in 8 months, and you tell them at that point, at 8 months, that you got another job, then they will pay you a lump sum of 4 months of the balance. So there's no particular legal term for it. It's just a circumstance of the negotiation that occurred in this termination, for instance, or if there's been no negotiation, whatever the company has originally offered. I mean, you're not held to that particular package. Many of my clients generally prefer a lump sum package, and that's what we're pursuing, something that doesn't have any obligation to go and notify the company about other employment. But the good thing, so you understand, Andy, is that even if this is the terms and conditions that have been offered to you by the former employer, again, presuming the package is actually a reasonable and fair severance package, at law, which you definitely want to reach out to the firm and get that assessed if you've not done so. And of course, we can be reached at employmentlawyer.ca. And of course, you can also use our severance calculator as well, just to find out, to make sure that the package itself, appears to be accurate and adequate in the circumstances. But let's say that everything on that is fine. Ultimately, the employer cannot police your efforts to find alternate work. And again, it's alternate comparable work, so a comparable job. That's what your legal obligation is, not just to find any job working at Harvey's, for instance, down the street. It's got to be a comparable position. So the employer can't police those efforts. You are entitled and permitted to basically kind of bide your time and make sure you find the right job for you. And as a result of that, when you find another comparable job, it's actually, again, legally comparable, so typically within 10% earnings of the previous job, then at that point in time you can say, okay, this is sufficient, and you can advise the company at that point. The company, again, cannot control your efforts to find alternate comparable work. That's up to you to act reasonably in doing so. So hopefully that answers your question. A couple final questions here just to get those quickly. Looks like Timothy from YouTube has asked, his brother has been a seasonal worker for 6 years, the same employer, things are slower. Now they're dodging his calls for the coming back. If they don't hire him back, what are his rights? So no, if he's been there for 6 years, again, a lot of it would depend on, for instance, his age, his rate of pay, his position, and things like that. And of course, the availability of comparable work. If you can get another job, doing the same thing at the same rate of pay, the next day, effectively with another company, then his severance entitlements would probably be quite negligible potentially. Of course, he may have minimum entitlements under the Employment Standards Act, but long and the short of it is, he would be potentially terminated if they don't call him back at that point in time, because of course the employer has to give him work and pay. And so, if he's terminated, then he's entitled to some kind of a severance package, probably, if there's no enforceable contract. So Timothy, I would suggest that you have your brother reach out to the firm. Again, we can be reached at employmentlawyer.ca and have somebody look at the circumstances here. If he is ultimately not called back to work and they just ignore him, because he may well be entitled to a severance package of a certain extent of money. So he absolutely does have rights in the circumstances. The fact that he's seasonal, not relevant. But I appreciate your question and thank you for that. Final question here. It looks like from YouTube again. Looks like Saga World Boss, another great name, has said, my company is going bankrupt and they are under credit protection. They told us that we are not getting a package. Can we still get the wage under protection program? Yes, you would be entitled to the wage earner, the WEPP that you've mentioned there, and you could apply through the Ministry of Labor. It's not very much money. Of course, you need to be confident your company is in fact going bankrupt. If it's just a ploy to get out of your paying your severance obligations, that's of course a serious concern. But if you're legitimately these folks are going bankrupt, then looks like that the WEPP would be your best recourse in the circumstances, because if the company can't pay you a severance package, then legally speaking, you can't pursue them. Of course, you can't pursue a bankrupt company for a severance package. There's no litigation that's possible there. So hopefully that answers your question there. That looks like all the questions for today. Hopefully everybody got their questions answered. And thank you everybody for joining us today and asking your questions. Please like and subscribe if you enjoy what we do here. And again, my boss, Lior Samfiru, will be on tomorrow at 1 p.m., our co-managing and founding partner, with another segment answering your questions. So thank you very much for attending this afternoon and take care.